Yes, Ms. Fottrell.
My Lords, good morning. As you know, I appear on behalf of the appellant, which is Slough Children First, and I appear with Ms. Brigadier, who sits behind me. You will know that Mr. Miller appears with Mr. Kayani, who sits behind him. Ms. Baisley, forgive me, Mr. Miller represents the first respondent mother, who sits at the back of the court. Ms. Baisley, King's Counsel, appears with Mr. Crispin, representing the father, who also sits at the back of the court, and then Mr. Pearce appears on behalf of the children through their guardian, who is not, as I understand, present in court, but joins by way of live streaming.
All right, good. Well, we're glad that the parents have been able to be here. Thank you. And also, I think I'm right, aren't I, that Mr. Crispin is the only person who's survived from the actual trial?
Yes, he is.
All right, good. Well, so he will be our invaluable source of information if any points of fact turn out to need to be answered. All right, well, now we've read and are grateful for the written submissions that have been provided. We've read all of those. We've read the important underlying documents. You can take it. And so we understand what the arguments are on both sides of this.
Yes, thank you, my Lord. May I just deal with a number of preliminary housekeeping matters? First of all, just to check that the court has all of the documents which it should have. You should have the appeal bundle, a supplementary bundle, which is a compilation of material from the court below. And there is obviously the authorities bundle. You should, in addition, have skeleton arguments from the first respondent mother and from the children's guardian, which were lodged after the bundle had been lodged.
We have all of those. Thank you.
There is then an application from Ms. Baisley and Mr. Crispin to adduce further evidence. May I just say that there is no objection to the court seeing that material and reviewing that material. In due course, we may have some submissions to make about its relevance, but it's obviously a matter for the court if it helps.
We've obviously read it. We won't decide now whether we're admitting it or not, but the parents can be reassured that we have that information in mind and we'll hear what anybody wants to say about it.
Yes, of course. Our position on behalf of the local authorities, we have no objection to the court looking at that material, obviously. May I also just alert you to one rather tiresome practical matter in relation to the bundle. Your clerks should have had an email this morning that the authorities bundle contained...
We did. Thank
you very much.
If we need to go to that case, we've got it elsewhere.
I'm grateful, thank you. We've had some discussion at the bar as to timings, depending, of course, on interventions in the court. I would expect to be about an hour. I think Mr. Miller has said that he will be about half an hour to 45 minutes, Ms. Baisley about 90 minutes, and I think Mr. Pearce...
Well, that sounds, if I may say so...
ambitious?
No, it sounds to me to be very abundant. There's no dispute about the facts in this case.
No.
There's not... Yes, Ms. Baisley.
My Lord, I gave them 90 minutes. I gave 10 minutes in respect of the application to adduce fresh evidence, and I gave another time, which made it up to a total of 90 minutes. There was then a concession that the local authority would not be seeking or inviting this court to make a placement order if the appeal is allowed.
Well, we'll see whether that concession stands or not.
If that concession stands, of course, I wouldn't be anything like as long.
Right, well, we won't spend time talking about time, but it's useful that you've had this discussion.
Yes.
We're seized with the appeal as it stands, and we're not aware of what discussions between you have taken place.
Yes. My Lords, I won't take up much of the court's time with factual matters, but may I just signpost and highlight a number of relevant issues in relation to the local authority's appeal. You will know, of course, that you are dealing with a very young child, who I will refer to as C, and that she was born on the 4th of May 2023. On the 16th of May 2023, she and her mother were placed in a local authority foster care placement. On the 31st of May, she and her mother went into a residential assessment under the umbrella of an organisation called Progressive Care. They were joined in that assessment on the 5th of June by C's two older siblings who are aged 11 and 6. They are K and J. They are, of course, as you know, not the subjects of this appeal, but they were the subjects of the proceedings in the court below and are now the subjects of care orders and are in long-term foster care. On the 31st of August, the assessment came to an end, and the children have all lived separately from each other from the 8th of November 2023, the two older children being in foster care and C being in a separate foster placement. You will know that the judgment of His Honour Judge Tolson, which is the subject of this appeal, was handed down on the 25th of April 2024 following a 3-day final hearing. The local authorities case, of course, we have set out in our
Just check one thing with you. The father was there for a month.
Father was there, I think, for 5 weeks, is my understanding.
I thought it was from the 5th of June to the 5th of July, or something of that sort.
Yes, I think about that, yes. He left on the 7th of July.
7th of July.
Yes.
So he arrived with the two other children.
Yes.
Thank you.
My Lord, you may have seen this already, but the local authority lodged quite a detailed skeleton, chronology, which
Yes,
you will
it's just
find
that the chronology and some of the underlying documents didn't say the same thing, so that's why
I'm aware of that. If I may, the chronology is more accurate, perhaps, than our skeleton argument in any event as to dates. And that sets out the dates on which the placement started and came to an end. And you'll find the chronology at page 56 of the electronic bundle, which is at page C1 of the paper bundle. You will know that the local authority's care plan before the judge below was for the older two children to be placed in foster care and for C to be the subject of a placement order. And in summary, you will know that the local authority's criticism of the primary criticism of the judgment of His Honour Judge Tolson was that he didn't properly grapple with the local authority's application for a placement order, and in particular that he didn't apply the correct legal test when dealing with that application, and also that the judgment in general terms lacks analysis. What I propose doing, if it assists the court, and I'm sure I'll be told if it doesn't, what I propose doing if it assists the court is to take the court through some of the relevant authorities in relation to making decisions as to placement orders, and then to take the court through the judgment and just to signpost the court to where we say His Honour Judge Tolson fell into error. I'm aware that this material is material which is very familiar.
Well, it's familiar to us in varying degrees, so
indeed,
please do undertake that.
So if I may just begin then, and we're looking at the local authority's ground one, that the local authority's ground one asserts that the judge misapplied the test, nothing else will do, and that there is a failure to analyse, in particular, the benefits or the potential drawbacks of adoption, and to balance those against
you've slipped into calling it a test. It's not the test.
It is not the test, and indeed, in slipping into calling it the test, I've fallen into the same error as the judge in the court below, so I'm grateful to my Lord for reminding me. May I just signpost the court to the authorities that we would like the court to look at, which set out how courts are to approach the question of determining placement orders, and of course the confusion which arose to a certain extent in the lower courts following the Reby decision in the Supreme Court. So if I could start by looking at the MH decision, which is a decision of Lady Justice McCurr, and that is in the authorities bundle. If you have an electronic copy of the authorities bundle, it's in the authorities bundle at page 164. It is tab 6.
Thank you.
And in particular, if I could direct the court to paragraphs 7 to 11.
Right, so situating ourselves in time, this decision of this court after the fundamental decisions in B and BS.
Yes, and that is helpfully addressed by Lady Justice McCurr at paragraph 7. And this, of course, is a reminder of the correct test to be applied. You can see this at paragraph 7. when a court is being asked to dispense with a parent's consent to a child being placed for adoption, that being the situation which faced His Honour Judge Tolson. And Lady Justice McCurr refers there to the decisions of BS, the Supreme Court decision of Reby, and the message which emerges from those two cases. Now, we say it's of some assistance to this court, and indeed to His Honour Judge Tolson, to look at the way in which Lady Justice McCurr unpacks those decisions. At paragraph 8, she says that I note the terminology frequently deployed in arguments to this court, and no doubt to those at first instance, omit a significant element of the test as framed by both the Supreme Court and this court, which qualifies the literal interpretation of nothing else will do. That is, the orders are to be made only in exceptional circumstances and were motivated by the overriding requirements pertaining to the child's best interests. She goes on to make the observations. In doing so, I make clear that this latter comment is not to seek to undermine the fundamental principle expressed in the judgment, merely to redress the difficulty created by the isolation and oft subsequently suggested interpretation of the words "nothing else will do," and the exclusion of any overriding welfare considerations in the particular child's case. I would invite the court to read on paragraphs 9, 10 and 11, because of course Lady Justice McCurr makes the important point that in any contested application there will be a number of options which are before the court, and when the court is looking at alternative options, and this is what she sets out at paragraph 9, third sentence, in others the options will be more finely balanced and will call for critical and often anxious scrutiny. However, the fact that there is another credible option worthy of examination will not mean that the test of nothing else will do automatically bites.
Right now, leave aside the question of whether we call it a test or not. What does that mean?
Well, my Lord, it means, and I think she goes on to explain this in paragraphs 10 and 11, it means that when one properly reads and applies paragraph 8, the exercise in which the court is engaged when determining... Does it, I'm sorry to interrupt you, but does it mean that the fact that there's another option worthy of examination doesn't mean you fail to show that adoption is necessary and proportionate? Yes, I think that is the point that is being made.
Biting means in this context.
Yes.
Right. It doesn't bite the local authority.
Well, it doesn't elevate nothing else will do to be...
As soon as there's something else to consider, it doesn't mean...
That nothing else will do.
Nothing else will do. All right, okay.
Indeed. She goes on at paragraphs 10 and 11 to explain the balancing exercise that the court has to undertake at first instance. And at the third sentence in paragraph 10, she says, the fact of a contingency plan suggests that something else would do at a push, the exact counterpoint of a literal interpretation of nothing else would do, and it will follow that the application would therefore fail at the outset. She reminds courts in paragraph 11, and we say this is still...
So, I'm sorry, again, I'm not finding this altogether easy to understand on its face. What I think is being said here is that if you have a situation where a local authority says, we're going to try and find adopters, but if we can't find adopters, we're going to find foster parents. That does not mean they can't have an adoption plan.
They can't have a placement order.
They can't have a placement order.
Yes, and that, of course, is very often the situation on the ground.
Yes.
The local authority will say the primary plan for a child is to place the child with the doctors. But, of course, if a search is fruitless, after a period of time, the local authority would have to consider alternative placements. And that would
all of this is being said, let's remind ourselves, in relation to a child who was rising 7.
Yes, indeed. But, my Lord, we say it is a helpful authority for this court and indeed for other courts because it focuses in on the dangers of isolating the term nothing else will do out of context or treating nothing else will do as a trump card or a stopping point in terms of a judge's analysis. And there is a very clear message from Lady Justice McCurr in this decision of the importance of courts still exercising rigour in terms of their analysis of the options which are before them and carrying out the balancing exercise. Of course, my Lord Justice Jackson may be more familiar with these authorities, but the context in which Lady Justice McCurr is providing that guidance is some confusion which arose after ReB and BS that in some way it brought to an end the possibility of a placement order because of the misuse or misinterpretation of the phrase "nothing else will do." And we say that that is present in this judge's analysis, but I'll take the court to that in due course. Could I then ask you to move on to look at the authority of ReW? And this is the...
Is the one that went missing?
It is, indeed. A later version of the same case appeared in the authorities bundle. I have hard copies, if the court would be assisted by having those. It is a decision of my Lord Justice Jackson, Lord Justice McFarlane, as he then was, and Lord Justice Lindblom. And we say that there's a helpful analysis again of the use of the phrase "nothing else will do," and it's at page 53 of ReW, beginning at paragraph 68. And this is a very clear and powerful revisiting of the difficulties which arise, and we say have arisen in this particular case. We would invite the court in...
I'm sorry, I'm just finding... You're at 68, are you? Yes.
Paragraph 68.
Right,
so if you have the
yes.
hard copy from the family law reports, it should be page 53. Now, just to put this in context, this was a somewhat unusual and difficult case because it involved a dispute between the natural family of a child and a child who had been placed for adoption on the basis of certain threshold facts which were subsequently demonstrated to have been wrong. So there was a compelling case for looking again at placement within the birth family. But the context in which Lord Justice McFarlane, as he then was, looks at this question of "nothing else will do" is against a backdrop of submissions that there was some primacy, if you like, to be given to the birth family, and that elevated the "nothing else will do" test. He begins at paragraph 68 just to remind the court and those reading the judgment of the decisions of the Supreme Court in ReB and, of course, the subsequent decisions of BS. And then, after the quote from Baroness Hale in her judgment in BS, forgive me, in ReB, he sets out there, in other words, the test is one of necessity, nothing else will do. Those are the words of Baroness Hale. But Lord Justice McFarlane then says this: the phrase is meaningless and potentially dangerous if it is applied as some freestanding shortcut test, divorced from, or even in place of, an overall evaluation of the child's welfare. And then he goes on to say the phrase "nothing else will do" is not some sort of hyperlink providing a direct route to the outcome of a case so as to bypass the need to undertake a full, comprehensive welfare evaluation of all of the relevant pros and cons. And he refers again to the BS decision. Paragraph 69, we say, is also helpful and of relevance to the decision before the court today. Once the comprehensive full welfare analysis has been undertaken of the pros and cons, it is then, and only then, that the overall proportionality of any plan for adoption falls to be evaluated, and the phrase "nothing else will do" can be properly deployed, or if one likes, returning to the decision of Lady Justice McCurr, that it bites, to use her terminology. If the ultimate outcome of the case is to favour placement for adoption, or the making of an adoption order, it is that outcome that falls to be evaluated against the yardstick of necessity, proportionality, and nothing else will do. Now, my lords, we say that that, again, is a helpful reminder of the context in which "nothing else will do" is to be deployed. And in particular, we say there is some relevance from this decision to the decision of His Honour Judge Tolson, where in fact to some extent he does appear to use nothing else will do in as a hyperlink, if you like, leapfrogging over the welfare analysis which he is required to carry out. But I'll come back to that, if I may, in due course. Two other authorities that I'd like to signpost the court to, if I may, very briefly. First of all, the decision of Lady Justice Black, as she then was, in the case of Re-V, which you'll find in the authorities bundle at electronic page 125, hard copy tab 4. And this is a helpful decision, we would say, because it is a reminder to the lower courts of how a court should approach this question of the analysis which is to be undertaken when long-term foster care is one option and a placement order is the second. And she deals with that, providing some guidance to lower courts at paragraphs 95 and 96, carefully caveating it that they are general observations, but we say they are relevant to the case which is before this court, because they're quite starkly setting out the sort of elements.
We had children there aged 9 and 5. I'm not trying to distinguish or compare the cases, just to have in mind what the sort of likely issues that will have arisen in the individual cases that we're looking at.
Of course. But the reason why we would signpost the court to this is of course that if it is going to be said, and I understand it may, that the judge did carry out an analysis of adoption as an option for C. One only has to look at the very general observations made by Lady Justice Black in the Re-V decision to see how some of the pros of adoption and the cons of adoption were not actually considered by His Honour Judge Tolson in the court below, and similarly, that his analysis in relation to long-term foster care, even in very general terms, if it's going to be said that is something he is entitled to do, it ignored many of the shortcomings and the challenges which arise for children in long-term foster care. And so we would say to this court that paragraph 96, 95 and 96 set out the sort of factors that one might reasonably expect in a welfare analysis, balancing out these two competing options. And then lastly, if I may, just signpost the court to the Re-P decision of Lord Justice Ryder, and the court will find that at tab 8. It is page 182 of the electronic authorities bundle, and in particular page 182, forgive me, just bear with me while I get the relevant paragraph. Yes, it is paragraph 57.
Just before you go there,
of course,
can I just check just one point? At paragraph 96 in Re-V,
yes,
which you were talking about, Little Roman 3, is that especially towards the end of Little Roman 3, about the position in relation to contact once an adoption order's been made? Is that true, accurate still? I mean, it's the last bit of it. Probably the last two sentences.
Yes, yes, which begins, I think it would be fair to say that such arrangements tend not to be seen. Is that
It's those two sentences. Is that still the position?
Well, I'm wary of dealing with that point as a general point, but it is the position one is aware.
Except you've put this forward as a general.
Of course,
proposition.
one is aware anecdotally that post-adoption contact orders are rare. They're rarely made by courts. The question of whether or not there is post-adoption contact does depend to a significant extent on the view of the adopter. So to that extent, that would still be accurate. If adopters are very strongly against it, it's unlikely to happen, which is, I think, the point that Lady Justice Black was making.
I thought in this case, the local authority are going to try and find adoptive parents who would be amenable to contact.
Yes.
If that search were to run up against the buffers, then
Yes.
they would have to
Yes.
widen the search.
Well, not only that, the Guardian, in fact, very strongly advocated for post-adoption contact in this case. And when giving oral evidence to the court below, the Guardian made it very clear that it was his view that the local authority would prioritise post-adoption contact when looking for adopters. I think it's fair to say for this local authority, post-adoption contact is something which it successfully promotes, but I can't say that the observations of Lady Justice Black are wrong. I'm not in a position to say that, but matters have moved on, and Miss Baisley very helpfully refers to the Public Law Working Group and some public speeches made by the current President, Lord Justice McFarlane, as to the importance of local authorities moving on and looking at post-adoption contact as an option for children who are placed for adoption. But to answer my Lord's question, that seems to be accurate as far as I'm aware.
Right. I think one way of checking this is to note that I think Lady Justice Black was speaking at the end of 2013.
Yes.
Looking to see July 2013. The provision in the Adoption and Children Act which allows for the court to make a post-adoption contact order is section 51A, which was brought in with effect from the 22nd of April 2014. So one immediately sees that the landscape has changed, and I doubt that there would be much disagreement at the bar that contact is much more thought about now than it was 10 years ago. No doubt as a result, in part, of the amendment to the main statute. And everybody may have a view, anecdotally, as you say, as to whether these orders are generally made or not.
Yes.
The power to make them is undoubtedly there, and Section 27 of the Act always made it mandatory for the court to consider contact when it was making a placement order.
Yes. Well,
And that has always applied.
well, that is right. I should also make it very clear that it was very much part of this local authority's case throughout that it would be seeking adopters, as my Lord indicated a moment ago, who would be open to post-adoption contact. And that was a genuine commitment on the part of the local authority. But one also has to acknowledge that if the trial judge had made it clear that it was his view at this point in the process that post-adoption contact is preferable for a particular child, then again, that is a matter to which the local authority has to give considerable weight. It isn't something the local authority can ignore, as it were, if the judge had a particular view that post-adoption contact, either with parents or with siblings or with parents and siblings, was a preferable outcome. So I hope that deals with that.
But while we're on contact, could I just ask you one point of fact? The judge said in his judgment that on the basis of his plan, which is that there should be fostering together or apart, that there should be a minimum level of contact of once a month, sibling and parent, and not confined to a contact centre. And he said that was a ruling, as it were. It doesn't appear to have shown up in the order that was made.
No.
Really, that may just be a curiosity, but I couldn't understand why, as the judge had said there was going to be contact not less than once a month, it didn't appear as part of his order.
I don't know that I can shed any light on that, but I can give some thought to it and come back to it. My Lord would like us to do that.
Right. Sorry, you were in...
Not at all. I was going to just...
You were in Re-V. Was there anything else? You've gone on now, I think, to...
Just very briefly...
Justice Ryder.
To look at the decision of Mr. Justice Ryder in Re-P. And again, this is a judgment from 2016. I was taking the court, just bear with me if you will, to paragraph 57, which is at electronic bundle 199, if the court has a hard copy, it's 199 as well, it should be. And this, of course, is something which has been, or an observation which has been repeated in many of the authorities, but it's a reminder from Mr. Justice Ryder as to the obligation of the court below to undertake a holistic analysis, and that's set out in BS and other authorities. But of particular relevance is paragraph 57, that there's no specially prescribed form for a judge undertaking the analysis, that the judge is doing little more, Mr. Justice Ryder said, than performing an old-fashioned welfare balancing exercise. It goes on at the bottom to say, forgive me, that the balancing exercise doesn't require the balance sheet of the pros and cons, and I'm at the top of page 200. So the debate about whether the analysis of realistic options is a balance sheet of the pros and cons, or an aide-memoire of the key welfare factors, and how they match up to each other, is sterile. What is expected is that the benefits and detriments of each option are considered, and there is an evaluation of each option as against the other based on that analysis. And that sentence, we say, is important in the context of any decision about a placement order, but it's particularly important in the context of this case, because it is that exercise that we say the learned judge failed to undertake. The benefits and detriments of each option were not considered, and there is not an evaluation of each option as against the other based on that analysis. So in other words, those were the authorities that I wanted to take the court to. May I then take the court to the judge's judgment? And obviously we've dealt with this in some detail in our skeleton argument, and I'll try not to repeat the points there. But if the court could turn to the judgment of His Honour Judge Tolson, there are a number of paragraphs in the judgment that we would like to just highlight for the court to illustrate the points we make in relation to ground one, that the judge had failed to undertake the balancing exercise. If we look first of all at where the judge deals with the law, and he does this at paragraph 14 and 15 in the first instance. At paragraph 14, and this is at page 71 of the electronic bundle, it is E4 of the hard copy. At paragraph 14, he sets out the relevant provisions of the Adoption and Children Act that he says are in play. Pausing there for a moment, the judge refers to section 47 and section 52. Section 52 does apply in relation to a placement order. Section 47 does not. And section 47 sets out the conditions which must be met when the court is making an adoption order. So that is an error on the part of the judge. He goes on then to characterise compulsory state-sponsored adoption as an exception, and then sets out his understanding in relation to dispensing with the consent of the parents. And it's in that context, at the end of paragraph 14, that he introduces nothing else will do as a phrase. He says, the higher courts have ruled, forgive me, that the word requires, and this is in relation to dispensing with consent, carries the connotation of an imperative in that phrase, forgive me, in the phrase that is always used on these occasions, if nothing else will do. Now we would say that that indicates some perhaps confusion on the part of the judge as to how nothing else will do is to be deployed, but it certainly indicates some difficulties in relation to the judge's thinking. He goes on then to refer to a note which is given, submitted by the local authority by Miss Cox, who was counsel at first instance. And Miss Cox set out quite a detailed and careful analysis of the law.
We've got that.
Thank you.
It bears looking at. It's in the supplementary bundle.
It is in the supplementary bundle, my lords, and it is at page 16 of the supplementary bundle.
So we have the set out over 3 or 4 pages some of the leading authorities, including some that you've taken us to.
Yes, quite. But of course, what is striking is that Ms. Cox's note sets out quite clearly and in some detail how the court is to approach its task, how the court is to undertake the balancing exercise, when and how the court introduces nothing else will do or adoption as a last resort. And helpfully, Ms. Cox set out at paragraph 5 of her note, and this is at page 17, she sets out those paragraphs from Lady Justice Black's decision of Re to give some general guidance to the court at first instance as to how it might evaluate the benefits and detriments of adoption as against long-term foster placement.
And at the end of this note, in addition to dealing with paragraph 8, particular considerations relied on by the local authority, at paragraph 9, there is mention of matters that were submitted to be irrelevant
Yes,
to the decision.
yes.
The judge.
And in our submission, some of those matters do in fact bear on the judge's thinking in his analysis. But Miss Cox, as we read this note, was dealing with issues that had arisen in the course of submissions. And it is, we say, quite telling that Miss Cox was addressing the judge to remind the judge that the substance of the threshold didn't itself bear on the decision. She reminded the judge that the care plan of the local authority did include, and you can see this at point B at the top of page 19, the care plan did include post-adoption contact, and reminded the judge also that keeping, as she puts it, keeping a child in long-term foster care for the sole purpose of facilitating contact between siblings ignored the fact that contact between siblings could be incorporated into an adoption placement. And then also we say, importantly, in the trial in the court below, neither the judge nor, it would appear from Miss Cox's note, any of the other advocates in the case sought any information or evidence about family finding. The point that we would make in relation to that is, of course, that the court, when making a placement order, doesn't need, and one might say is not entitled to have or doesn't require evidence as to adoption placements and, if you like, the adoptability of a particular child once the local authority has carried out the necessary assessments in relation to medicals and so forth. That is not a matter for a judge making a placement order. That is a matter for a judge making
I wonder,
an
is
adoption order.
that correct as a total statement? There will obviously be cases in which the age of the child or the characteristics of the child or the number of the children that are in the group that is being considered for adoption will immediately strike the court as being ambitious to the point where it might actually be impossible, not just hard. Surely there will be cases in which it will be appropriate for the court to ask whether the option is really a realistic option because of the special circumstances. But does your proposition defeat that suggestion?
Well, I'm not sure that's what I was saying, but if that's the impression I gave, then let me clarify. The point is that when a judge is making a placement order, he's not prevented from making a placement order by the absence of information about prospective adoptive
No, but there may be cases in which it would be foolish to make a placement order without having that sort of information because of the particular circumstances of the child.
Of course. Of course, and there may be circumstances where there are older siblings who are in placements, and whether or not a child can be placed with older siblings is a factor, and so on and so forth. But the point I'm making, I think, is a slightly different point, which is if the court doesn't have information about the availability of placements for a particular child, that doesn't prevent a judge from making the placement order if the judge carries out the welfare evaluation and reaches the conclusion that that is the correct order. And the reason I make that point is, of course, that when His Honour Judge Tolson comes to undertaking his analysis, he does, we say, elevate certain factors in relation to the possibility of placement of this child for adoption in a way that we say is wrong. But returning then, if I may, so that is the note prepared by Miss Cox, and we say that that is a helpful note, and Miss Cox set out the law as it is, and it should be applied. Returning then to the judgment, you will see at paragraph 16, and this is page 71 of the appeal bundle, you'll see at paragraph 16, the judge sets out a summary of Miss Cox's note. And he says at the bottom of paragraph 16, I also have to be careful to consider all the options put before me holistically. That is to say, without ruling out first one and then another to leave myself in effect with Hobson's choice. Now, he's right in making that assertion, but we say he didn't return to that when he comes to his own analysis of the options before him, because what he doesn't do is to look holistically at the possibility of placing this child for adoption. So if one then moves on to the part of the judgment where he turns to C's case, you will see that he does that at paragraph 31, and that is at page 73 of the electronic bundle. It is E6 of the hard copy bundle. He says, I now turn to C. As I understand the law, regardless of the age of the child, it is necessary to discuss, to conduct a full analysis of the pros and cons of the orders, rival orders proposed. He says, I cannot, as I understand it, be sufficient simply to proceed to an adoption care plan from the point at which family placements have been dismissed without considering other options, and in particular long-term foster care along the way. Now, all of that we say is correct, that the judge is correct to make those observations, but he then leads himself into error because he doesn't do what he says he should do. And perhaps one can see that he signposts himself, as it were, in the wrong direction, because he makes the observation at the end of the paragraph, I understand this and I make no criticism of individuals involved, because in truth it is what I encounter in most cases. The approach for local authorities seems to be that for children below a certain age, if there is no family placement, then adoption it will have to be. And he sets out the local authority evidence at paragraph 32 and the Guardian's view in relation to that. And at the end of paragraph 32, he says that he did not have the evidence before him from the local authority or the Guardian in relation to long-term fostering, and so I feel it necessary to conduct my own analysis. Rightly, he makes the observation that there is a unique combination of factors which are in play. But again, we say those points in his judgment are correct, but he then fails to return to those issues. So the analysis essentially...
Let's just unpick this. Firstly, is it the obligation on a local authority to provide an analysis of what exact foster placements might be available for child or children in these circumstances, any more than it's obligation to provide information about the availability of adoptive placements?
Well, my Lord, the obligation on the local authority, as my Lord is aware, is to provide an analysis of the realistic options for placement. And in this case, the local authority identified two realistic options for placement, one being return to family members. The local authority's view was that that was not realistic in this case, and the second was a placement order for this young child. The options in relation to the siblings were obviously different.
Yes, but that doesn't answer my broader question. I mean, I'll put my cards on the table. My experience is not that if a local authority is approaching a court in care proceedings, where one option might be foster care, whether it's realistic or not, that the court requires the local authority to say what foster home
Yes, forgive me, I misunderstood.
is going to be provided, or I mean, the court decides in principle what is right
Yes.
for the child, and then the local authority has to get on and provide it in practice as best as it can. But we don't spend our time in the family court leafing through estate agents' particulars, as it were, of this fostering home or this adoptive home,
Yes.
subject to the caveat that there may be cases where the child's needs are so particular that no court could make a sensible decision without knowing what might be available in broad terms. But I mean, if the reason I've interrupted you at this point, because you seem to be about to pass over it, is that if the judge thought that there was a crucial gap in the evidence about what was available, he was in no better position to go on and make his own decision than you were. If he was wrong about that there wasn't a gap in the evidence, that your local authority was just doing what local authorities do in these cases, then he had to confront that. So I'm as it were, just querying whether you say that was all right up to then.
Well, my lord, there is a difficulty in this case, as my lord has identified, that the judge reaches a conclusion early in his judgment, we would say, at this particular point, that he doesn't have evidence from the local authority that he thinks he needs.
Well, if in that case, he's got to adjourn to get it.
Precisely so.
He can't go on and simply dismiss your application because you didn't provide it. And that calls into question as to whether he was right that he needed that information.
Yes. Well, let me deal with those 2 points. First of all, of course, my lord is right that if he identified a lacuna in the evidence, then the correct approach is to pause and to require the local authority, and perhaps the guardian also, to address that lacuna by investigating matters further. But I take my lord's point, and we would say that of course is correct, that it is a local authority is not required to provide evidence as to a catalogue of prospective foster placements or a catalogue of prospective adoptive placements. The local authority is entitled and indeed obliged to put forward a welfare case, and the welfare case here was for a placement order. But the difficulty, of course, then is that this judge goes on to, as it were, colour it in himself and to make some general assumptions and presumptions as to the suitability of foster care without having the evidence. So yes, and my lord may be making that observation because I think it is the case of one of the respondents that because the local authority failed to make good its case on the evidence in relation to a placement order, then the judge was entitled to continue in a sort of linear way to deal with the next option on the conveyor belt, and that was a foster placement, and that we say is simply wrong.
As I understand it, what you're saying is that it's for the court to make its decision as a matter of principle on the assumption, putting aside an extreme case of the type my lord suggested, as to what is in the best interest of the child.
Yes.
I'm paraphrasing the test we've been looking at. And then on the assumption that the local authority will then get on and attempt to implement it.
Yes, it is, forgive me, it is what order will best serve the child's welfare.
Yeah. I mean, it must be the case that if one of the options was simply not feasible in practice and the local authority knew that, then they should bring that to the attention of the judge, because that would be part of the analysis to be performed. But except in that sort of extreme case, or the sort of extreme case my lord was indicating, where there was very particular needs of a particular child, you're saying that the general principle is the court makes its decision as to which order is appropriate, and then the local authority gets on and attempts to implement it on the basis that presumably if there are discovered to be insuperable problems, then the matter may have to come back to court.
Well,
is that the way it works?
Well, not exactly in relation to matters coming back to court,
okay.
But what one is aware of reasonably regularly, that if a judge at first instance is of the view that they don't have the evidence they require to make a welfare decision between a number of options, or the court reaches the view that the local authority has failed to properly explore a particular option, then the judge can pause, and judges do pause and require local authorities to further investigate or bring to the court evidence as to the feasibility of a particular option. And it could as easily be the other way round. It could be that a local authority would be proposing a foster placement for a very young child, and a judge may well require other options, including placement orders, to be explored. I hope that answers my lord's question. It's a decision in principle that the judge is making based on the judge's evaluation of the evidence as to where the child's welfare best interests lie. And that, of course, is to be evaluated within the framework of the welfare checklist in Section 1 of the Adoption and Children Act. So welfare best interests of a child who is very young may prioritise stability and security, and that will lead into it.
I think we were. I don't want to go too much off what we were actually discussing here. The question is about the obligations of the local authority to put evidence before a judge as to the feasibility of the options that are presented. And I think the general view is that that isn't the job of the local authority at the decision in principle stage, save in the sort of extreme circumstances.
Well, the local authority has to identify the options that it says are, on its view, based on its read of the evidence and its assessment and its evaluation of welfare, the best options for the child. I think we may be at cross purposes, and I may not be answering my lord's question.
Well, let's rather than, as it were, delay by trying to answer my question. I think I've understood what my lord's put to you and the obligations of the
local authority identifies what it considers to be the realistic options. Realistic, as has already been discussed, implies that you could actually do it. Might not be certain, but it's possible that that could be the achievable goal. Mm-hmm. If the court, for example, thinks that an option is not realistic, that it's said to be realistic, it'll explore that in the evidence. If the court thinks that local authority has left out of the list something that is realistic, it will challenge the local authority about that. But these are decisions at a quite high level of principle.
Yes.
And it will only be in particular cases that it will be necessary to get down closer to the ground and work out what actually is or is not there in a particular case. And I think the drift of your appeal is that there was, that C is a very special child, but there was nothing special about her case that would cause the court to depart from its normal approach.
Yes. My lord puts it better than I do. Thank you. Just returning then to the judgment, and I won't labour these points, but the analysis, insofar as it is there, is between paragraphs 33 and 39. We make a number of points about the way in which the judge deals with C's case in paragraphs 33 to 39. It's not entirely clear, reading the judgment, what are the factors that the judge identifies from the welfare checklist as being of particular importance. At the bottom of paragraph 33, he says, I attach significant weight to C's age in this analysis. He doesn't return to that issue, nor does he in any way indicate how he links that question, the age of this particular child, to the two potential outcomes. How is age relevant to foster placement, and how is her age relevant to the question of an adoption or placement order? That, of course, is particularly important when one bears in mind that for a younger child, the court has to look at the question of stability and security for that child. And the local authority's case in this particular circumstance was that stability and security for this child was best achieved by way of a placement order. So that observation or identifying of that issue, we say, is to some extent just left hanging by the judge. He doesn't return to it. He doesn't properly analyse it. At paragraph 34, he goes on to say, other factors I do not place in any particular order of importance, but these are the important ones. He identifies some issues in relation to the child's health, sets out some observations that he has drawn from the evidence, and then he says, it is a factor to be weighed up, it seems to me, not least because a proposed fostering to adopt placement proposed by the local authority had put matters on hold because of some issues relating to the child's health. Now, 2 points we would make there. It's not entirely clear what it is that the judge is saying about this child's health that impacts on A, the possibility of a placement order, and B, the possibility of long-term fostering. But second point that we would make is there wasn't evidence before the judge, nor would one expect evidence before the judge in relation to this particular child that would suggest that her health was a factor which would undermine the possibility of her being successfully placed for adoption. And so again, one is left in a position of the judge identifying a factor from the welfare checklist and not properly grappling with it in terms of his evaluation or analysis. At paragraph 35, he goes on to make some observations in relation to the parents. And we say that those are, again, to some extent, left hanging because the judge, we think, is referring to that part of the welfare checklist that deals with the child's relationships with her birth family. But that is a rather muddled sentence, we would say, in relation to that.
I didn't read it as being to do with the relationship with the birth family. I read it to be to do with her characteristics.
Well, my lord, that's one way of reading it. It's not entirely clear, we would say. And then he goes on at paragraph 36 to deal with...
Well, I don't see any other way of reading paragraph 35.
Very well, I'm not going to argue with my lord about that. In relation to paragraph 36, he goes on to deal with a submission made by Mr. Crispin in relation to the child's the parents' learning difficulties, and some submissions made by Mr. Crispin in relation to that. And then at paragraph 37, he turns to what seems to be the most important factor for him in his analysis, 37 and 38.
Well, I'm not meaning to slow you down, but paragraph 36 also contains the dismissal of your client's case, which is that once the threshold is crossed and you're dealing with welfare, then you don't get a different result because it isn't crossed for one reason or for another reason. But when it comes to issues of contact, it would be relevant. But there's a fundamental fact as to whether if the parents either can or can't bring the child up.
Yes.
And it doesn't matter whether that's for one reason or another. In this case, it's for no fault of theirs, whatever.
Of course.
That was the point that was being dismissed here.
That is the point made by Miss Cox in her note that we took my lord to a few moments ago. Just moving on then to the question of the position in relation to sibling group, and it seems to us that the judge prioritised or elevated this above all other considerations that C is part of a sibling group. He goes on to say, how does that weigh in the question of long-term fostering or adoption? All he says in relation to adoption is that she'll be parted from that group, although the plan is for contact in the future. It might be very much harder to achieve, and certainly can be achieved less frequently than if she were in foster care. That we say is not an adequate way of the judge dealing with the relevance of the child's relationship with her siblings in the context of adoption. He doesn't there acknowledge, for example, that this child has not lived with her siblings, say, for a brief period of time. He doesn't acknowledge that this child is...
That's not quite fair on the judge, is it, given the third from last sentence?
Well, it doesn't factor, let me put it differently, it doesn't factor in his analysis of the relevance of the sibling relationship.
That's a different point.
Yes.
He does mention that she's not been brought up with them for long periods of time. I mean, that's a slightly different way of putting the same point, but to say he didn't acknowledge it is, I think, unfair to the judge.
Well, perhaps...
He may not have evaluated it, which is a different point.
Indeed. But perhaps the difficulty is this, that the tenor, if you like, of the analysis is somewhat declaratory. The judge makes a series of assertions, which he then doesn't go on to evaluate or analyse. And
I think what you're saying is that he asked a question at the beginning of that paragraph and then didn't answer it.
Yes, thank you.
But I'm just conscious that you've got to be careful, as it were, not to suggest, which I think you did, that the judge hadn't actually even understood the point or acknowledged the point.
No, I'm grateful. Thank you. And if one then goes on to continue down reading those paragraphs, the judge turns to his analysis at paragraph 41, having listed a range of factors. At paragraph 41, he says, against this checklist, how do I weigh these factors? And we say that the analysis which takes place in the next 2 paragraphs is really too superficial to meet the obligations which are set out. Nowhere in those paragraphs, 41, forgive me, 40, 41, 42 and 43, does the judge identify what one would call the benefits and the detriments of a foster placement. Nowhere does he identify in particular the difficulties which might be faced by this child in long-term foster care. He doesn't, as it were, weave into his analysis those factors which he had identified in paragraphs 33 to 39. And crucially, and we say in very stark terms, nowhere in those paragraphs does he properly focus his analysis on the question of the benefits and detriments of adoption to this very young child. And one is left, we would say, with a somewhat linear analysis, albeit a very superficial linear analysis, because it is quite clear from reading the judgment that the judge had a preference for long-term foster care in relation to this particular child. But he doesn't evaluate the evidence in support
But is
of such a placement.
Is it not so much that he's come? I rather understood it's not so much that he comes with a preference for long-term foster care. It's just that if he's, as it were, misunderstood the initial test of nothing else will do, he's just looking to say, well, is there something else that will do? And in that sense, he looks at long-term foster care and finds some indications in favour of it, and then says, well, okay, well, they're not. In essence, he's approaching it from the wrong perspective of simply answering with a very literal hat on the nothing else will do test.
Well, there is that, but there is also, we would say in this judgment, a linear approach taken by the judge, that he's ruling out options and focusing on the option of long-term foster placement. What is somewhat puzzling in my submission is what he says at paragraph 43, because at paragraph 43 he brings himself back to the welfare checklist under section 1 of the Adoption and Children Act and reaches a conclusion which doesn't, we say, follow from his analysis, such as it is, or his evaluation of the evidence. For all these reasons, applying the welfare checklist within section 1 of the 2002 Act, it seems to me that it would be in C's best interest to search for long-term foster placement. And it's difficult from that sentence to understand what it is that the judge has in mind.
Will you say that that's just what the President was warning against in Re W?
Quite. So, my lords, standing back then from the judgment, we say it's very clear that this judgment does not undertake the exercise which the judge is required to do. And we say that in particular there is a stark deficit in terms of his evaluation of the evidence, in terms of his analysis of the evidence, in terms of his failure to identify benefits and detriments of the options and to weigh those against each other and to arrive at a conclusion as to where this child's welfare best interests lay. Now, I don't propose, unless you wish me to, addressing ground 1 in any further detail. We have in our skeleton argument and in our grounds also raised other issues in grounds 2 and 3, in particular in relation to the lack of reasons. But from the discussions between my lords and I this morning, it seems to me that there wouldn't be any particular benefit to my addressing those matters in detail unless you wish me to do so.
Well, just consider this. I mean, quite often on appeal, but not in this case as it happens, a separate ground of appeal is that you disagreed with the professionals, and in particular the child's guardian, but you didn't sufficiently explain why you were doing that. In this case, the judge's reasons for departing from the unanimous professional advice seems to be based upon his perception that they were obliged to put forward more evidence about fostering than they had done, and that they were obliged to regard it as being a realistic option. Were there any other reasons that he gave for departing from the professional advice?
My Lord, not that we can identify in his judgment. He's very critical, and I think I took the court to this in paragraphs 14 to 16. He's critical of an approach by local authorities and guardians generally. He makes a general observation in relation to very young children, that where a court is dealing with very young children who cannot return to their birth parents, there's an assumption that adoption is the correct outcome. So that, I think, is a reason that he gives for delving deeper into the long-term foster care option. But there aren't any other reasons that we would identify that he gives. We do make some general points, and I know my Lord will have seen these in our skeleton argument at page 38 in relation to ground 3, as to the lack of clarity in terms of the reasoning generally in the judgment. But I'm not going to take my Lord through my Lord's own judgments on those matters. May I then move on to deal very briefly with the question of what we say should happen if the court grants the appeal?
Could I just pause there? And what we have in writing is the appellant's notice in which the local authority seeks that this court should substitute a placement order.
Yes.
Your skeleton argument rather ran out at the point where one would have expected it to deal with that. Miss Baisley was well alive to that and grapples with the options that face the court if it considers that it has any business setting aside the judge's decision. And those, as it seems to me, would be to remit it if we were satisfied that there was more than one realistic option for this child, or if we were satisfied that there wasn't, to make the order that you have sought so far. So that's where matters stand,
Yes.
as far as the court is concerned, to this point.
Yes.
Right. Where do we go from there?
Well, my Lord, we don't press an outcome that if this court is with the local authority in relation to the appeal, we say that the matter should be remitted to a judge.
Why?
Because, my Lord, we do accept that there would be an opportunity or a requirement for the local authority to provide further evidence in relation to long-term foster care. That evidence
Why?
is not.
I thought your whole point was
Yes.
the local authority doesn't need to.
Well, my Lord, the local authority's position in this case is that the court doesn't need evidence in relation
Right.
to
Well,
long-term.
we're going to rise for a moment so that you can take some instructions about this. Give you 5 minutes in the first instance.
Could I have 10?
Yes.
Thank you.
And if you need more, let us know.
Thank you.
Escape, stretch legs. Very much.
Don't let him off the hook. It's not as well. Really?
It is.
Yeah,
It's
it is. It's
cooler
really
than outside.
nice. 75, it's like a nice box, it's lovely. Oh, really?
Trouble is all these layers.
Mm.
That's the downside, and they're all sort of wool and you ask for more time?
Yeah, 5 minutes.
5 minutes. Right. We're not on stream at the moment, are we? Oh, we are.
Yeah, that's great. Nice. Yeah. Sorry, of course. Yeah. No worries. Yes, I'm sorry. Thank you for the time. Yes. Yep.
All right, available.
Yes, Ms.
My
Roger.
Lord, thank you for the time. I've had the opportunity to discuss matters further with those instructing me and with the team manager, Ms. Nkugi, who sits at the back of the court. The local authority would invite the court to substitute its decision for the decision of the court below if the court is satisfied that the appeal should be granted in this case. And we would say that there are three matters that the court particularly should have regard to in evaluating that decision. First of all, when one looks at the welfare checklist under Section 1, it is abundantly clear that for a child of the age of this child, a child of the age of C, security and stability of a placement is a fundamental and central factor, and that was a matter on which there had been considerable evidence from the local authority and the Guardian, which was not properly grappled with by the judge in the court below. And we say when the court is looking at the welfare checklist, and this is similar to the signposting by Lady Justice Black in the Revie decision, that when one is looking at the welfare checklist for a very young child, delay in relation to placement is relevant, stability of placement is relevant, and therefore Section 1(4)(d) of the welfare checklist has particular weight attached to it in relation to any young child, but in relation to this young child in particular. Secondly, we would say that the local authority at the time that it made its placement application had, of course, to satisfy all of the statutory criteria in relation to the making of the placement order application. And that included preparing the adoption medical, which undertook the exercise of assessing and evaluating the child's suitability for adoption and any relevant health issues that arose, but also it included the child permanence report and a decision made by the agency decision maker. And all of that was material which was before the judge in the court below, all of which satisfied the statutory criteria in relation to the making of the placement order application. The third point that we would make is that, of course, a placement order is a permissive application, a permissive order. It allows the local authority to place the child for adoption. if an adoption placement can be found and identified. And that is what the local authority seeks, is the permission to do so. That does not ignore the possibility, should the child not be capable of being placed, of alternative options being explored.
Well, why should we even be considering that in this case?
You don't have to consider that in this
No,
case.
but I mean, we've got to deal with these matters in the light of real-world experience. And unless it's going to be suggested otherwise, whether or not the appeal is allowed, this little girl is now just 13 months old.
Yes.
There's no way in the world that there aren't adopters for her.
Yes. Well, I won't press that point. The last point, of course, is to reiterate, and those sitting behind me are keen that I would do so, that it has throughout been the local authority's case that it would seek adopters who are committed to post-adoption contact. That is very much the approach which is taken within the local authority adoption team, and the senior lawyer from the local authority adoption team, Miss Lacey, sits behind me. She is very clear that prospective adopters who come forward to this local authority are assisted and encouraged to look at post-adoption contact.
Right, so as a matter of fact, is this an in-house search at the present time, or has the agency had to go more widely?
I think it is an in-house search, but I'd have to turn my back. In-house.
Yes, by that I mean the local authority has been looking at its own bank
Yes.
of prospective approved adopters.
Yes.
It's not a case in which it's had to go out to make a national search.
No.
Indeed, one wouldn't expect that for a child of this age in the first instance. Now, one of the things that the court is required to do, any court, when making a placement order, is to consider the question of post-adoption contact, and under Section 26, the court, whichever it is, has got the power to make a contact order. What is the local authority's submission in relation to that?
Well, my lord, we would say in this instance, as in any case, that the court has to look at whether it is necessary to make an order. And in circumstances where the local authority has consistently had a commitment to post-adoption contact, but also contact under the currency of the placement order, that the court doesn't, in this instance, need to make an order. There's no question here that the local authority would not adhere to the indication or the decision from His Honour Judge Tolson that contact should take place on a monthly basis under the placement order. It is a matter for the adoption court.
Yes.
Thereafter.
Right, so the provisions of the care plan with regard to C are to be found pages 343 and 344. At least in my
Yes.
edition,
The care plan.
it's a tab 8.
Yes, 339 is the final care plan for C.
Yes, and it's at pages 4 and 5
Yes.
of the internally of the care plan. PDF 344.
Yes. That is the position as the local authority puts forward. I'm turning my back just to make
could
sure
you
that I'm
just check
correct on that.
please?
Yes, you can hear what's probably being
Yes,
said
I-
behind me, that is the position.
Yes. Is there anything else?
Not from me, thank you.
Thank you, Ms. Fotcher. Yes. Who will go next?
We have discussed and agreed that I should go first, my lord, if that's convenient to all.
Right, so you'll go first, and then Mr. Miller will tell us what you've said.
He has made some separate points which we respectfully adopt in relation to the scrutiny of judgments and so on, and he may want to elaborate those. My lords, I think it is worth just looking again at the welfare checklist in section 1.4 of the Adoption and Children Act 2002,
Yes.
page 415 of the authorities bundle.
Yes.
Because that sets out not only what the judge was required to consider when making his holistic welfare analysis, but also what he was entitled to expect the professionals to provide him with in their own respective analysis of welfare. And of course, in the case of adoption, paragraph 1.2, parent consideration.
Sorry, I've lost where you've gone.
I'm so sorry. 415 in the authorities bundle.
Sorry.
I hope I've got the right reference there.
Yes, it is.
Thank you.
415.
So we're in section 1 of the
You'll just have to give me a second to get there.
Of course.
Yep, sorry.
This is, as you say, applicable not only to the court but to the adoption agency.
Indeed.
In this case, the local authority.
Yes. And paramount consideration, of course, paragraph 2. Delay, paragraph 3. And then 4, the matters to which the court or local authority in this case must have regard. Wishes and feelings, of course, not so important in the case of the child of C's age. The child's particular needs, I'm going to come back to that because I submit that is significant. The likely effect of the child throughout his life of having ceased to be a member of his or her original family and become an adopted person. The child's age, sex, background, and any of the child's characteristics which the court or agency considers relevant. And that's, again, I submit, an important aspect of the checklist in the case of this particular child. Harm, certainly, and then the relationship which the child has with relatives, including, of course, in particular, siblings. The likelihood of such relationships continuing, the value to the child of it doing so, the ability and willingness of any of the child's relative and any such person to provide a secure environment, wishes and feelings. And then the other matters in the following subsections. One of the difficulties for the judge in our submission is that by the time the matter came before him on the 23rd to the 25th of April this year, the evidence in relation to matters relevant to the checklist, and in particular the child's needs and her particular characteristics, was old and we say out of date. And if one looks at it, the judge gives a hint of why that may be. There was no social worker in post since December 2023. The most recent information before the judge about C was in the social worker's final statement dated 15th of December 2023, when she was only 7 months old. The final care plan is of the same date. There was an updating social work statement in slightly later in December, but that dealt with a separate incident. And the combined final analysis of the Guardian was dated the 31st of January and related to inquiries made a little while before that date. So some 3 months old and based on somewhat older information.
So what I mean, this meant that the reportage arose quite soon after the separation of the children
Yes.
from their mother,
Yes.
which is good in the sense that that was still a fresh state of affairs, and no doubt because of the court's timetable, it then took another 3 months for the matter to come before the court. What changed, other than the reduction in the ability of the parents to see the little girl?
The pre-permanence medical assessment identified that as a child of two parents with significant learning difficulties, this child had a 50% or greater chance of having learning difficulties herself. What was not produced to
So the date of the medical was?
the 17th of October 2023.
That was known about at the time of the evidence being filed.
It was. It was.
What I'm focusing on, because sadly the situation that you're describing is not at all unusual.
No.
That the parties are ready to go, but the court is not.
Yes.
And I'm trying to identify, because I can't think of it myself, what it was that was lost from the information store as a result of the 3-month delay in the matter getting before the court.
Well, it may explain, my lord, why although it doesn't really excuse it, why a health assessment by the health visitor, which identified that the child was delayed in all areas of her development, which was made in February 2024, so some time before the matter came before the judge, gave rise to significant concern about her development in all areas.
But it wouldn't be the fact that there is this medical which gives you a figure, in a sense, is we're dealing here with something that is really common knowledge.
Yes, but it's common knowledge that a child of parents with significant learning difficulties risks having learning difficulties herself.
Yes.
But here there was evidence that this child was significantly delayed in all areas. In some areas she scored 0. And that wasn't put before the judge, and therefore he was entitled to say he didn't have good evidence about the child's...
So what wasn't put before the judge?
This health visitor assessment dated February. It's
sorry.
one of the documents that we have put in as a late document. It was produced yesterday in response to our request.
Well, that I haven't seen.
Right.
Can we deal with this in an orderly way? You're the author of the application. I don't mean you personally, but your client is the author of the application for fresh evidence to be admitted.
Yes.
Is that right?
Yes.
And I thought that was to do with an in-placement meeting minute.
There are two applications. The first is in relation to that minute, looked after child review.
Right. Well, can we deal with them formally, as it were? So
Yes.
let's identify that application and see what turns on it.
Yes,
um,
thank you.
I'm just going to
Application dated the 18th of July is the first in time.
just a moment, if you would.
Of course.
Right. Now this is to do with a looked after child review
Yes.
of the 3rd of July.
Yes.
Right. And
And it contains some information about the child's health.
Sorry, you're going to have to slow down, because can somebody give me either a reference to where it is in the bundles,
I'm
or if it's not
afraid
in the bundles, then...
It's a late application dated the 18th of July when that document came to light, and it's not in the bundle, my lord.
does anybody have a hard copy for my lord?
Or you can tell me where I can find it electronically.
Does that be on CE file? Just getting it up.
It will be on CE file.
Because I've got an undated more recent.
Well, that's the one I have.
Yeah. That's the one you have got, or not?
No, haven't got.
I've got that one, but not the one you're talking about.
Right. While we're at it, I think that my lord has the more recent one, but I don't.
I can provide the more recent one.
Thank you. And
In several
could somebody
copies.
lend their copy of the 18th of July application?
No. Yes, it's this one. Thank you. It's this one. I'm grateful to my learned friend that the first in time is being handed up.
Thank you.
Oh, it's both. Um,
Hang on.
for my Lord Justice Snowden,
I've just
the
been
earlier
given
application is here. Just
So I was going to say, I've just been given 2 copies of the ones I've got, of the thing I've got.
yes.
already.
May I hand up the thing you haven't got?
Sorry.
I've got 2 applications.
Yeah, but it's the same one.
I've now got 3. Yeah, I've got that one.
I handed up
Sorry.
many hard copies, and I think that may have caused
Yeah.
confusion.
This is something that was attached to an email yesterday.
Yes, I've already got that.
Yeah.
Yeah.
apologies.
Take that back, 'cause I've already got that.
First in time, 18th of July. As my lord says, it deals with looked after child review the 3rd of July. If one goes, and you'll see the order we're asking for permission to produce and rely on it. If one looks at the first page of the document itself.
Hang on, you'll have to wait. 'Cause
I'm so sorry.
we're just not with you yet.
If you just don't worry, don't do anything more. I'm just going to give my lord the one that he is missing,
Thank you, my lord.
which can be done quite quickly. See if the email comes through. Right, we'll stay for the moment with the 18th of July application.
Yes, thank you. And the document is just behind the draft order. I don't know, my lord, if you're there, but the first page of the document has in the bottom box headed update on previous actions.
I'm sorry, can we just start with the application notice?
Yes,
Right, I'm just checking that my lord has
I've got it.
received that. Right.
thank you,
The application notice was sealed on the 19th of July,
thank you.
and you're asking to admit fresh evidence in the form
Yes.
of the CLA review on the
Dated-
17th of July. Right, so that postdates the judge's hearing.
Yes.
And what are you asking us to look at in
The first page
document
of the
itself?
document,
Which hasn't come through.
Sorry?
I've got 10 pages, which is, unless I'm just being stupid, stops at the end of the application.
Yes, that hasn't helped. I'm sorry. I have seen this child looked after review. Does anybody please have a paper copy of the child looked after review that they can lend? We can.
This hasn't come into my...
Here we are. It was a further document which I could have sent you but didn't. Right, we can resolve this for ourselves. Thank you.
thank you very much. I can hand up
Right,
just
well,
the document.
Don't worry.
okay.
It's for my Lord Justice Snow.
Thank you. That's the one.
Yes,
There we are.
Thank you.
thank you.
Right. So
Box towards the bottom, update on previous actions.
yes,
And below that, Catherine Vanson, that's the health visitor.
yes. Okay. Don't read things out because
Yeah.
we always get the names.
And reference to a health assessment in April. And then sharing a review health assessment dated February. And there are hints in this document that there is a need to review development. That comes from the third page under Dear Chloe, because these...
That's what I'm asking you to not read out.
Sorry. And then the top of the next page referring to physiotherapy to assist with gross motor skills. And then various other matters that aren't of such significance. But having noted the reference to a developmental assessment in February 2024, we asked for that document. And that document came through yesterday and is the subject of the most recent notice.
Right. So that's the application of the 29th of July.
Yes.
And we won't trouble about whether it's been
I have,
issued or not, but for the moment, you essentially say that these two things go hand in hand.
yes. And if
Right, would you don't read out anything from this, but just take us to which passages you want us to particularly focus upon.
page 3, please, to start with.
This is of the document itself,
Yes,
and this was an assessment of the 26th of
February.
February.
Under does the carer, second box down.
And this health assessment is being done in what context?
The health visitor, because of concerns about development.
Okay.
And
Thank
then page
Page 3 at what
the second box down on page 3.
Yes.
The carer.
Thank you.
And then page 5 is an assessment of development, the top half of that page. And in particular, the final box, right-hand side, due to scoring low, etc., in the black zone. And the possibility that it might be due to hearing. And then the final 2 pages, starting with the bottom box on the penultimate page, the further reviews that were to be carried out in June, April, May, and so on. And the local authority provided a document this morning. I don't know whether the court received the email from the GP. Dr. Akhtar.
Just a moment.
I don't think it's been sent to the court.
No,
Oh,
not that I can see.
Well, if they just see you filed it, what do they do with it?
Right.
I'm sorry, my lords. I received it this morning, but if I might summarise for now, hearing said to be normal, so the possible explanation for the delay not due to hearing. And also, curiously, the local authority's email to the GP says that in relation to a discharge, because the child had, under general anaesthetic, an investigation of her hearing fairly recently. And the local authority on the 19th of July wrote to the GP saying, having received the written discharge form, it raises a query about delayed speech, deafness and autism. The last of those seems curious in a child of this child's age, but nevertheless that seems to have come from a discharge summary from the surgery. And then the GP says, we didn't diagnose autism, she is going to be assessed by the different team, her hearing is normal.
Right. Okay. So does that give us the general picture?
The gist
Yes.
of the concerns.
Right. So let's suppose that and we certainly take note of it. We'll give our decision as to whether we formally admit it or not. But that doesn't even concern you. What does that amount to in the context of the appeal?
It's relevant to the criticism of the judge in the local authority's skeleton argument. And it's paragraph 21 at E27, electronic page 27, in relation to the judge dealing with this child possibly having learning difficulties.
Is this adoptability?
Yes, and making what are and her particular characteristics. So in our submission, it goes to the welfare analysis.
But why does it make her more or less adoptable?
I'm not dealing with adoptability at the moment, if I may. I'm dealing with her characteristics, her needs, and whether, well, I suppose it does flow into adoption, whether she might need a specialist adoption placement, or whether is going to be a difficulty with obtaining adopters. One of the things that was within the papers was that couples had said, well, we don't want to go forward with our application, despite having been approved for adoption, until we know more about her health. Now, I accept that that was relating more to her hearing, because it's nowhere in the papers that a prospective adopters received that this child has developmental delay. But certainly there is evidence in the papers that it was putting off couples who said, at least we want to wait and see.
Well, can we be clear about this? This is all about adoptability.
Well, it is
I mean,
about...
what else could it be about?
Well, it's about how her needs are best met and whether one can say...
Yes, but how could they be better met in foster care?
Well, if there weren't adopters who could adopt a child with significant learning difficulties, for instance, one
Well, that's to do with adoptability.
But then one would be considering a specialist foster placement.
But I mean, on the face of it, I mean, we don't want to alarm people.
No.
But I mean, the sorts of things that are being talked about here are relatively commonplace in the experience of the family court. Obviously, there are cases that we'll all be familiar with, where there are very, very serious health issues, maybe birth-related, and so forth, where one's not talking about a child that is likely to follow a normal career in childhood at all. But, I mean, in this case, I'm at the moment struggling to see where this information takes one, because it can just as easily be said that if a child has some difficulties of this kind, all the more they need a family who is their family. I can't see that this information really goes anywhere in relation to the sort of decision that the judge was faced with.
Well, in our submission it does, because it's very early days in working out quite how...
But what do we do then? We leave her in limbo for the several years that it will take to know how she's going to turn out?
No, with respect, we wait some months until a better assessment of her needs can be made.
Okay.
And
so it's the argument is that this raises issues of adoptability and what the most suitable type of home is likely to be. Therefore, we should wait.
Well, the judge did say it is open to the local authority to seek a placement order at a later date. And he made the point that there was a lot of information missing. Now, I appreciate that goes to the question about whether he should adjourn. He should have adjourned, but I would like to address that a bit later
yes,
on, if I may. But it is of a concern that updating information was not put before the judge. It was available from February, and it wasn't put before the judge, and nor has the court below, or indeed this court, seen all the further assessments that were to take place. Now, a number of those post-dated the hearing before the judge, not the April ones, of course, but the later ones would not have been available. But it might have informed a decision about whether it was necessary to adjourn, bearing in mind that there were to be investigations into developmental screening. There said to have been one on the 4th of April, febrile convulsions, and so on. And it's particularly important since the court was told in the care plans and the care plan for C that the parents would be notified of all medical appointments and assessments for C, and where possible and appropriate will be invited to attend up until the adoption order is made, and the reference for that is the main appeal bundle at E376 at the bottom of the page.
Can we just unpick, and maybe that Mr. Crispin is best placed to help about this. But your submission seems to suggest that information was not available to the court. But paragraph 34 of the judgment shows that the judge was aware of the hearing issue.
Yes. And he was aware of the pre-adoption, the 17th of October 23 medical, which simply gave statistics for children of parents with learning difficulties.
Also, is what you're able to tell us now, with the benefit of the further documents, very different from what the judge was hearing?
Yes, but this child was very significantly delayed in all areas of her development. The judge was not aware of that. He was aware of a potential problem with hearing and of the statistics in relation to children of their parents with learning difficulties.
Did I understand you correctly to say that the hearing issue has been investigated and resolved?
Yes, that's the email from the GP that's just come through and was sent to me this morning.
Right.
And says
But that's following
an investigation under general anaesthetic.
which wouldn't have been done by the GP.
No, it's surgery, and the local authority was asking the GP about the discharge summary from the surgery, which had said dealt with hearing, but also raised the possibility of autism and so on.
Okay.
And so that's very recent information. I think that investigation under general anaesthetic took place earlier this month.
But just to put it very simply, the other issues that have been identified about delayed development or the like, it's not explicable because of a hearing problem.
Yes, that's my point.
That's
yes.
the point.
Yes,
just put very simply.
Yes, it was thought that the delay might be due to not hearing,
But that's not.
but
the
that's
case.
now been ruled out.
Right. Okay.
So, and it's relevant to what is said in Re-T placement order about it's not a reason not to make a placement order that we don't know that an adoption placement is going to be available. But if this child does have very significant delay, it is relevant because...
But I'm still not getting... I mean, you say, well, we wait some months. Well, at that point, one can obviously see that somebody will then say, well, we have to wait some more months. And on it goes into the years. But I mean, why should a... Let's suppose that we took a gloomy view of this.
Yes.
And that instead of it being something that is resolved reasonably well with the sort of medical attention that she is now getting.
Yes.
Let's suppose it turned out to be something that was more concerning. I'm still not understanding why that makes any difference, because otherwise it would be effectively, to put it bluntly, discriminatory. That you don't go ahead with what is otherwise the best plan because you continually have to wait. I mean, that's where the delay principle that you took us to comes in.
In our submission, one takes a step back and says, is it actually the best plan? Or is this child going to be better
But you can
off?
decide that. I mean, let's suppose you're thinking about two C's, not just one C. You're thinking about the C that we all hope for, and the C if there are some medical difficulties.
Yeah.
Both of those C's need a family.
Yes. But if the reality is that the second C is not going to be adoptable by...
Well, in that case, the adoption plan fails. I mean, all it is a plan.
Yes, but
And one falls back upon what is next. But that I can't at the moment see that with uncertainties of this nature, which are not unusual, one is left saying, well, this child must be for fostering, because nothing, no parent could deal with these problems at an adoption.
But if that were known, and we don't have all the assessments that seem to have been carried out, haven't been shared with the parents and so on. If that were known, it might mean that it's not possible to say that adoption is necessary or required in order to meet the child's needs. And one would have to, and I accept that the court can't interfere too much in the local authorities carrying out of its plan under a placement order, but it is a concern that none of the professionals who were saying to the court that this is the best, this is really the only option, because you didn't really consider any other option for this child in our submission, didn't look at learning difficulties that had already been identified by a developmental assessment. And there was no family finding evidence. The court often does have that, particularly in the case of a child with special needs. And the court is able then to make an assessment in terms of the likelihood of the child being placed soon for adoption, within a reasonable time for adoption. And there was no family finding evidence here. I accept nobody asked for it, but the parents had not been made aware of the February assessment. They didn't have the material that would no doubt have caused them to say, well, hold on, if this child has these difficulties, she's right at the bottom of the scale, and in the black zone, which is really off the scale for difficulties, we need some family finding evidence.
I appreciate that the court is not bound by the position of the parties, but the issue of there being no family finding evidence, but do you mean in relation to adoption, to fostering, or either?
Either.
Yes.
None
So
at all.
if effectively, and those who were representing the parents took what I would regard as being the conventional approach to this,
Yeah.
Which is that the court decides in principle and the local authority then does.
Yes.
And that's how the trial proceeded. So this initiative was the judge's initiative.
Yes.
It didn't come from any of the parties.
No, I accept that.
So the judge saw a gap,
Yes.
but no party saw.
Well, no party pursued, certainly, but had they had the February assessment, no doubt they would have seen it.
I just wanted to look at one reference to judgment which also might bear upon this, which was to do with the, I can't pull it up just a moment, but it's to do with the potential differences between this little girl and any potential adopters arising from.
I think it's when the judge dealt with if there's a significant cognitive difference.
Yes.
That might be a disadvantage. I think we'll just find the reference. I do remember seeing it, my lord. And it was in the context, and against that he said he adopted Mr. Crispin's submission that if that were the case, then there would be benefit to the child in having life story work done, which the parents could be involved in, because
It's around 35 or 36, but
yeah.
in paragraph 35, the judge was thinking about version 2 of,
Yes.
of the child.
Well, he was concerned quite clearly about it, as he put it, that the extent of any difficulty she may have was an unknown.
So I'm at the moment thinking about the extent to which this further information, which is obviously of interest to everybody, including the parents,
Yes.
really differs from what the court was aware of, because we've got a situation in which the written evidence was supplemented by oral evidence from both the former social worker and the guardian. And they obviously will have conveyed quite a lot to the judge, of which
Yes.
we don't have a transcript.
Well, he does say he doesn't have a proper professional analysis, so I don't concede that they conveyed a lot in their oral evidence. Is it the paragraph 36 point, my lord, about learning disability, which applies to C's parents?
Yes, can you point to the,
Yes.
it was some rather unusual remark the judge made about how child and carers would
Yes.
fit.
Yes, it's where he deals with Mr. Crispin's point about. Oh, I think it might be 41, my lord.
Thank you very much.
Starting with the third sentence, it is of course entirely possible.
That is it not a
Well, he's
very unusual remark?
It's
One can't tell what possible relevance it could have.
well, one could see that it's relevant to her needing the actuality of her family, to understand any intellectual difference between her and her adopters. But at that point, he's speaking about it in terms of a possibility, perhaps highly likely. He doesn't have the material that has now come to light.
Well, I suppose that's been very helpful in relation to the new material. We don't want to let that overshadow your main submissions, but have we got your point in relation to those documents?
I think you have, but it does go to the re-T point about placement orders, and
could you put that in?
yes,
Unpack that point.
Yes,
RET says you don't you don't deprive people of adoption because you're not certain they're going to get adopted.
But it does say, unless there is reason to think that they are not going to be available or ready for adoption for some time.
Right.
So there's a qualification in RET, and in fact, in that case.
Sorry, can you just, for those who don't have RET at our fingertips, can you just.
Yes, RET is in page 4 of the authorities bundle.
Paragraph.
Page 17.
It's paragraph 18, I think.
18.
(17) is what Ms. Cottrell relies upon. Paragraph 18 qualifies it and says
Right,
that
this is children not ready for
it's not
adoption.
ready for placement. Now, I accept that may be a more extreme case than what is known about in C's case, but in that case, the court declined to make a placement order, and that was on that basis. So it's not the case that the court would just not look into such difficulties, and our submission is the court should have looked into such a difficulty, should have had the material placed before it to see whether the child was likely to have such difficulties that she would not be ready for placement. For
Those
adoption.
are boys aged 7 and 4.
Yes, I accept that.
Yeah,
And I accept this is a much younger child, but that goes to different considerations in our submission. And it's simply the point on RET that it's not always the case that the court doesn't look at whether the child is adoptable. And that sounds unkind. I don't mean it in any way to be unkind, but adoptable by parents who may be put off. Evidence of couples who had been approved and did not want to go forward yet, and I accept this relates to hearing, may I just give you the reference? E323 in the appeal bundle, F2177 and F216. There were two issues. First,
sorry, those don't do us any good.
sorry, E323 and 324, electronic page 323 and 324.
323, thank you.
And there were two issues. One was the level of contact.
E323.
Sorry, just page 323 electronically, my lord.
Yeah, well, I've just dialed 323 into my core bundle. Is that what you want me to do?
Yes.
And say which bit of this page? It's F246.
Yeah, so sorry, I'm just.
Doesn't seem to relate to.
No, it doesn't.
So sorry.
I think that must be a misreference.
Yes, I'm so sorry. May I provide it in a moment so as not to waste your lordship's time? Apologies. Sorry. Oh, it is at the bottom of the page. Thank you. Grateful to Miss Whittaker. Apparently,
Bottom of 323.
F216.
F.
The bottom right reference is F216.
Thank you.
Electronic 323.
216 F. 216.
My F. Okay, like my electronic bundle doesn't take. My bundle takes me to
We're getting there, and it's
30 pages away.
292.
yes, thank you.
It's actually E292. Okay.
I've got it at electronic page 323 at the bottom on.
No, it's definitely not. It's F293. I think. By the look of it. So E293. Sorry, I should say. Electronic 293.
Yes,
It
it's at the
may
very,
be-
very, very bottom of our 293 and into 294. Thank you.
Thank you. So two matters, supervised contact and hearing. But our submission is that if that applies in the case of the contact, that would still be an issue. And secondly, if this child has the sort of learning difficulties that were identified in February, would be likely to be relevant too.
But as I understand it, RETI says that that is not a reason not to make a placement order if all other factors point in that direction.
Yes, but our submission is those factors don't point in that direction. If the child is a child who's going to need specialist care, the court would then be considering in a holistic welfare analysis against adoption the foster placement that would have specially trained foster care as a specialist foster placement, as it's sometimes referred to, which can meet the needs of a child with special needs.
But then to take my Lord's questions to you, how long is it going to take for that evaluation to arrive? Is it 3 years or what?
We don't know, but because we don't have the various documents which it is said the local authority was going to obtain for this child in April and May and June, and there's still information missing.
Well, I think we've now
Yes.
grasped
Yes.
the submission on those.
Yes. I have got some points about the parents' scores and so on, but this is a case where the full-scale IQ of the mother is 57 to 65 and the father is 56 to 64.
Yes.
I won't say any more than that, but the court has the point.
Yes.
I do submit that when scrutinising the judgment, it's not right to conduct a contextual analysis, and that the local authority's skeleton argument really comes close to that by looking at one paragraph and then the next paragraph. I do rely on the authorities which say that one has to look at the judgment as a whole, not pick out bits. The fact that the judge went wrong by reference to section 47 is not fatal to his judgment. He correctly identified.
I quite agree. And if that was a serious problem, then somebody could have popped up and told him so.
Indeed.
Yes.
Indeed. And similarly, he doesn't have to set out a checklist. We referred to the authority in relation to that. It's probably not necessary to look at it, but sometimes a balance sheet is helpful, but it's not a requirement of a
Yes.
judgment. And what we submit is that it was perfectly plain from what the judge said in his judgment, the basis on which he declined to make a placement order.
Well, could you put in in your way, what, why that is, what was his ultimate, instead of putting it, he wasn't satisfied that there should be adoption. What was the judge finding was best for C?
What he was finding was best was to remain in foster care, ideally, as he put it, with her half siblings.
Why?
Because of the benefit she would gain from the sibling relationship, which I invite the court to take judicial notice is the most important and enduring relationship that any child has throughout her life. And she had bonded with her siblings. There was evidence about that before the judge. There was regular contact between them. He pointed out...
Well, the evidence that you're referring to there is the together and apart report, is it?
It's the together and apart report. It's also the care plan. It's also there's an acceptance by the guardian that contact is important.
Yes.
So that there is a relationship, that there is a bond, and the social work statement also refers to there being a bond between all three children, clearly stronger between the elder two. The judge makes the point, we say rightly, that none of the professionals considered the issue of any alternative to adoption for C, and they did so based on her age.
Well, is that right? They didn't consider any alternative. The way it was put to us before was that they considered two possibilities, one return home and the other adoption, but they were not prepared to give much time at all to any intermediate position.
I of course accept that they considered a return home, but that had already been ruled out, and
Well, it hadn't before the hearing.
Well, another judge had sanctioned the separation.
But that was just
yes, but
interim.
I accept that was interim.
Right. So we were talking about the criticism is not they only looked at one option, although they clearly preferred one option.
Yes.
The criticism is that they only looked at two when they should have looked at three.
Yes, that's quite right, my lord. Thank you. And that is apparent from the local authorities' documents.
I mean, nobody at the hearing before the judge was arguing for foster care for this child. That was the judge's initiative. It was obviously an alternative
Yes.
case that was being made by the parents, no doubt, as being less bad than adoption.
Yes.
But actually, the main event was between the children coming home and them going for adoption.
But there was I accept that, but there was a requirement to consider all viable options. First, to consider whether they were viable, and second, to balance once against the other. And one of the points the judge makes, and we respectfully agree, is that it's not acceptable to say that just because a child is young, one can only consider adoption as being viable once one's ruled out the parents. And that was the approach of the local authority. And I'd just like, if I may, to go to some...
Well, is it that one can only consider adoption, or that it's obvious that this is not a good arrangement for a child of this age, and that one considers it, reaches that conclusion and passes on?
Well, in a holistic welfare analysis, it wouldn't be appropriate to say, well, it's obvious because she's under one or she's one.
No, but it's obvious in her circumstances. You don't then, there's no obligation then to go on and do a welfare checklist and a pros and cons, or something that one considers to be evident.
Well, it is necessary in our submission to look at other options, even if one then discounts them. Of course, her age meant that permanence and a sometimes called a forever family was an important consideration, but it's not obvious when the child has parents who will not disrupt a placement, when the child has siblings with whom she's had a life, and when the child may have particular needs that may mean that her family is particularly important to her. And we submit that it is a wrong approach to say, well, it's obvious that it's adoption because of her age.
Well, putting it another way, whether one says that it's obvious or not, one contemplates it and one immediately sees what it entails.
The obvious benefit is we accept the stability and security of a forever family. And
Where is that found in the judgment?
I think it is found in the judgment. He sets out that I wonder if I might track through, because
He didn't exactly put it quite as well as you did at the end of 41, if that's as far as he got. If that's unless there's something else, I mean, it is the only place he took that into account at the end of paragraph 41.
I think paragraph 33 as well. He turns to see at paragraph 31, page 103. And then he deals with it also in terms of her age and ability to still to form primary attachments at paragraph 33. So he has in mind that she is a younger child, that's an important factor.
But when he's actually doing the weighing, sorry, as I understood the structure of this judgment, he weighs the factors between 40 and 42, 40 and 43. So,
yes, I think
how does he actually bring it into his weighing?
Well, he goes through what he describes as other important factors at paragraph 39, and then goes through further paragraphs, going through to 43, and refers to contact and the local authority's very restrictive view at 44. Recognises in paragraph 45 that the children would need to move. And those passages we submit show that he has in mind all the factors for and against the options of adoption or foster care with siblings.
But we were particularly talking about the extent to which the judge actually took into account the benefits of lifelong membership of an adoptive family.
Well, I think he does that.
And you were asked the question where, when he evaluates the options, does he actually take that into account? And I thought the evaluation of the options was essentially done between paragraphs 41 and 43.
I'm not sure it's as carefully structured as that. He deals with, he recognises...
That's one of the problems, isn't it?
It's not the best structured judgment, I accept that, but if one takes it as a whole, he's recognised earlier on.
Yes. He seems to be giving it some, he seems at the bottom of 41 to be giving it some faint recognition.
Yes, he acknowledges that the age of this child is an important factor. He recognises that, and he recognises it in terms of her ability to form attachments to new carers. In other words, he's talking there about adopted carers. So he does have it in mind, but then he clearly considers that balanced against that is the need for this child to know her family and her siblings as she grows up.
Could we, it's been important to see that submission through to this point, so we've oversat a little bit. It could be a good moment to pause now,
Oh yes, thank you very much.
and we'll resume at 2:05.
Thank you.
I think so. The courtroom will be locked over lunch, will it? Thank you very much.
Yeah.
Obvious. That's